The 2022 Workplace Class Action Litigation Report is one of our preeminent publications every year, and we're so excited to have you. So a couple of administrative points. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located at the right side of your WebEx window. We will do our best to get everyone's questions, but if your question is not answered, our presenters will follow up with you after the event. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write the code down. It will not be repeated, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation today. Now on to the good stuff. I'd like to introduce our speakers. So Paige Smith is with us. We're so pleased and honored to have her as our special guest today. Paige is a reporter at Bloomberg Law, where she covers labor and employment matters and where she has received numerous awards for her work, including the Porter Award for Labor Reporting. In 2021, she was a finalist for the Dateline Awards given by the Society of Professional Journalists for her reporting on long-haul COVID. Prior to Bloomberg, she was a State House news correspondent at the Boston Business Journal. She holds a Bachelor of Science degree from Boston University. We're so pleased to have her join us today and share her professional insights into the latest key trends in workplace class action litigation. Joining Paige, we have Jerry Mattman. As many of you know, Jerry is a partner in our Chicago and New York offices here at Seyfarth and is the co-chair of our class action practice group. 2021 has again been a remarkable year of achievement for Jerry, including most recently his authorship of Seyfarth Shaw's annual Workplace Class Action Litigation Report for the 18th year. For the 4th consecutive year and 6th time in 7 years, Jerry was selected by Law 360 as an employment MVP, an award that recognizes the top 5 attorneys in the U.S. for each respective area of law. And just this past week, Chambers recognized Jerry's work in its 2022 global ranking, stating that Mr. Mattman is absolutely phenomenal and one of the top class action minds in the country. For thought leadership, Jerry has continued to be recognized among the most widely read and quoted lawyers in the employment class action field for his contributions in legal analysis and commentary. This past year, he received mention in a wide range of news outlets, including Fox Business, the Wall Street Journal, Forbes, Fortune, Law 360, CNN, and many others, including USA Today. So a little bit about the Workplace Class Action Report. Hopefully some of you were able to tune in early for the video that we just shared, but this is the 18th annual report. It's our flagship publication of the firm and manifests our excellence in defending class actions. It has been referred to as, quote, the Bible of class action law by EPLIC magazine. Quote, a resource that no practitioner or business executive dealing with class actions should do without. It is the leading treatise in this space, end quote. At 825 pages and covering 1,607 rulings, it was profiled in nearly every major media business section, including Fox Business, Forbes, Bloomberg, Reuters, USA Today, Law 360, and Fortune. The research and writing that goes into the report is nothing short of phenomenal. It is done on a daily basis. Our database of cases that we have analyzed over the past 18 years now includes over 25,000 rulings, which allows us at Seyfarth to identify trends and guide our practice, as well as ensures that our clients have the latest information on topics that concern their business. So let me turn it over now to Paige and Jerry. Welcome.
Thank you folks for having me. Jerry, would you like to say a few words or should I jump right in? What would be best?
Paige, why don't you jump right in? You're the headliner here.
Sounds great, folks. And thank you so much for having me. And I should say from the outset, I'm really looking forward to hearing your questions. There is so much going on right now, and there's a lot to watch, so I'll just start with that. But my name's Paige Smith. As Laura said, I'm a labor and employment reporter with Bloomberg Law. Specifically, I am on Capitol Hill, not at this moment in time, but I cover labor and employment policy on Capitol Hill. So anything coming out of Congress that impacts the workplace is something that is on my radar. There are a few things to watch, and I'll kind of divide it as sort of into like Hill expectations and then agency expectations, or workplace agency expectations to be more specific. Um, but in terms of some Hill developments, there are a number of things that are going on, some even happening just next week. So that's sort of how I'll kind of break up my presentation. But if there are any other any questions, I'm happy to answer those too. So a few things that are on my radar at this moment and that might be of interest to you folks is there are a number of employment law bills that are seeing some action and have seen some action. So the first of that is, there are companion bills that would essentially make arbitration agreements unenforceable for workers alleging sexual harassment and assault. This bill we could expect a House floor vote on this bill as soon as next week. So this is something that's in the immediate future. And on the Senate side of things, the companion bill in the Senate already has, 10 Republican senators supporting it, so it could theoretically overcome the filibuster threshold. So this is a bill that very well could become law soon. And to be honest, the topic of arbitration has generally been gaining a pretty good amount of traction on the Hill. There was a wider bill that would have banned all pre-dispute, or it wouldn't have banned it. It would have made unenforceable pre-dispute arbitration agreements, and that saw some action in the fall. But that will be another kind of variable continue to watch. Another bill that is sort of on our radar right now is the Pregnant Workers Fairness Act. So that cleared the House in June, and it also cleared a Senate panel in August. And there's a pretty good, there's some good bipartisan support on that bill. So that's another one that could potentially see a Senate floor vote in the near future, and would obviously have some significant workplace implications. It would provide more protections, essentially, for employees seeking accommodations during and after pregnancy. So moving on to the Protecting Older Workers Against Discrimination Act, that's another employment law bill. That's another employment bill, which this would essentially make it easier for workers to prove age or disability bias. And that cleared the House in June. So it's sort of hung up in the Senate at the moment, but it has seen some traction in the past few months. So we'll watch that closely as well. The last two bills that are on my radar at the moment are the first is the Pump for Nursing Mothers Act. That cleared the House in October, and it would essentially extend existing protections to more categories of workers taking breastfeeding breaks. But again, that's something that, it's still sort of tied up in the Senate, so we're not sure if there's a path forward for that one. The last one is the Protect Older Job Applicants Act, and that would allow older workers to allege a seemingly neutral hiring practice is discriminatory. And that the most recent action was that it cleared the House in November. So those are sort of a few bills that are on my radar at the moment and would have, very direct and sometimes significant, workplace implications. And another bill that I know is certainly on the minds of many is the PRO Act. That saw some action last year, but in terms of a Senate path forward for that bill, it's looking less and less likely. So that's, again, we're sort of watching it, but we're not sure what the prognosis of that would be. So a few other wider things to watch on Capitol Hill at the moment. Obviously, the Build Back Better Act. Just before I logged on here, I saw that Senator Joe Manchin made a very decisive statement, which is that the Build Back Better Act is dead. How it proceeds, or how President Joe Biden proceeds with this sort of landmark piece of legislation, we'll have to see what happens there. But there were a number of labor and employment developments that were originally proposed in this bill that we're not really sure where they'll go now, or if there will be further legislation pushing on these items. But I mean, the House passed version included things like a paid family and medical leave proposal, increased FLSA and OSHA fines, civil monetary penalties for NLRA violations, and significant enforcement funding for workplace civil rights agencies. So, if that bill really is dead, as Senator Manchin says, then those items will either be back in the drawing room, the back to the drawing board for those items, or we'll see where they go. Another thing that we're watching on the Hill is just the action of the unions. President Joe Biden has been labeled as, the most union-focused president at this moment in time, but we haven't necessarily seen that bear out in legislation yet. The infrastructure public law was obviously it was very beneficial for unions, but the labor organizations were promised more. So we'll have to see how this plays out over the next year before the midterm elections. The last sort of Hill thing on my radar, I'll say, are just nominations for some key top positions at labor agencies. We're still waiting on the nominations of David Weil at Wage and Hour, and we're also waiting on Jose Javier Rodriguez. The EEOC general, there's still a vacancy at the EEOC for its general counsel, which is a huge role, as you folks know. And then also Commissioner Janet Dillon, former Chair Janet Dillon at the EEOC, her term is expiring in July. So kind of a number of personnel movements to watch on the agency side of things. So from here, I'll kind of switch over to chat about a few agency expectations that are on my radar. And I'll start with the EEOC and then jump into the OFCCP. I should say, before I was focusing on labor and employment policy on Capitol Hill, I was an EEOC OFCCP reporter with Bloomberg Law. So from the EEOC, we're still sort of expecting some form of a pay data collection from the agency. The National Academy of Sciences report is due at some point this year. That would essentially, there was a pay data collection that was conducted, a court-ordered pay data collection that was conducted by the agency, and this report would essentially analyze the findings of that report and also advise the agency on how to proceed. That is something that's been closely watched, and when she was chair, Janet Dillon promised that there would be some sort of pay data collection moving forward. And I know current chair Charlotte Burrows has also expressed interest in this. So it's just sort of a matter of how the agency will take action on this. And another sort of personnel point, but the agency is likely to lose its Republican majority at some point this year. And perhaps the agency will be split, the commission panel will be split 2-2, Democrats and Republicans, but we'll see how quickly they can get someone confirmed for that Democrat seat. And then just another thing is like I mentioned, the general counsel seat is vacant at this point in time. So, the general counsel would likely come in making, sort of wanting to make a mark on workplace civil rights law in some capacity. And there are a number of areas where the general counsel could do that. So that would be another development. Lastly, from the EEOC is a really interesting initiative that I find personally fascinating, just this artificial intelligence initiative. It was sort of spearheaded by Republican Commissioner Keith Sonderling, but it also has the buy-in of the chair, Charlotte Burrows. Commissioner Sonderling has said he wants to pursue a commissioner's charge it's basically a targeted probe of artificial intelligence discrimination on this. So that would be something to watch pretty closely. To sort of flip over to the OFCCP, Jenny Yang is the director over there, and she is, she previously was an EEOC chair, so there's sort of this expectation that collaboration between the two agencies is coming, and we've sort of already seen that borne out with their the newly rolled out Hire initiative, but more collaboration is likely to come. And another thing is, we're kind of watching to see if the OFCCP will also initiate its own pay data collection if the EEOC doesn't necessarily step up as quickly. The OFCCP has sort of a history of looking into this area, and the OFCCP has, significant enforcement capabilities when it comes to pay equity. So this could be something that the agency would look into. Um, Last 2 points on the OFCCP. One thing that's really interesting, especially for folks who are very focused on federal contractors, is this AAP verification portal, or the Affirmative Action Plan verification portal. So far, this portal, this sort of online portal, only requires contractors to certify that an affirmative action plan is in place. But folks are kind of watching to see if this portal could change in some capacity and perhaps collect or require contractors to submit their affirmative action plans. So that is sort of a question that has been raised around the portal in particular. The last thing from the OFCCP is just it's the agency's sort of overall enforcement efforts. There has been only one lawsuit filed by the agency thus far under the Biden administration, but we sort of anticipate that that will change as the audits sort of kick up in intensity. And attorneys have said or have told me that the enforcement intensity has already heated up. So more litigation could definitely be on its way. And so that's sort of all that I have for now in terms of Hill and agency updates, but I'm happy to take questions and happy to continue the conversation with Jerry. Thank you for having me.
Well, thanks so much, Paige. Great insights as always, and sincerely appreciate your expertise and willingness to assist. My name is Jerry Mattman, and what a great honor it is to share the virtual podium with Paige. As you might imagine, I am a huge fan of hers, read what she posts every day in terms of having her thumb on the pulse of what's going on in Washington, D.C., and I think the kind of inside baseball views that Paige just provided gives a great roadmap for employers about what is important and what is likely to come down the road this year out of Washington, D.C. It's a great honor for me also to be here today with our book launch for our 18th annual Workplace Class Action Report. It's a labor of love for myself since I've been at it for 18 of the 40 years that I've been a lawyer. And as Laura had mentioned, we now have a database of 25,000 rulings. And so my challenge today is to make sense of the 1,607 rulings that came down from federal and state courts throughout the United States from January 1 of 2021 to December 31, and distill those down into a few minutes and give you my sense of what it means for employers and what sorts of trends were manifested during the past 12 months and what employers can expect in 2022. And to do that, I thought of dividing that discussion into 5 parts to talk a bit about settlement trends and what those show us about the past year and what we can expect to see in the next year, the all-important trends with respect to how courts react to motions to certify class actions brought by plaintiffs' lawyers, what's going on at the government administrative enforcement level in terms of the types of lawsuits and actions brought by the EEOC and the Department of Labor, the continuing impact of COVID, what I would call the COVID overhang, and what that meant for businesses, what it meant for litigation, and what it meant for class actions, and then the continuing impact of arbitration since it was authorized and green-lighted by the U.S. Supreme Court in its Epic Systems decision in 2018. And then I'll end with respect to what employers can do today to batten down the hatches, control risk, and to get through 2022 without being visited by any of these particular problems. So I'd like to start with those class action settlement trends. This is the cover of our book, and you might say to yourself, well, why are those settlement trends important? By my way of thinking, those settlement trends reflect 2 things: the focus and direction of the plaintiffs' bar and government enforcement regulators and litigators And in this area, there's a notion that success, defined by large settlements, begets copycats. And what I have seen over the last 18 years and during my 40-year career in defending employers is successful lawsuits, class actions that result in large settlements tend to create a life of their own in terms of other lawyers, other plaintiffs bringing those sorts of matters. Success truly begets copycats. So by their very nature, these large settlements tend to impact courtrooms, judges, plaintiffs' lawyers, plaintiffs' governmental regulators. And the way in which we try to distill trends in this area is to look at 5 categories of workplace litigation, and those are employment discrimination, wage and hour, ERISA, government enforcement lawsuits, and a 5th category, kind of miscellaneous statutory claims based on laws that impact the workplace outside of those 4 other categories. And so what did 2021 show? Well, the settlement numbers were off the charts. They were the largest they've ever been in the 18 years that we've tracked them. And in essence, they more than doubled from the prior year. And this was all the more remarkable by my way of thinking because it was against the backdrop of the pandemic. And certainly when the pandemic started, there was a lot of commentary by economists that cash is king and that companies would hoard cash and cut expenses and not spend much money. Well, the exact reverse happened in terms of the payouts, in terms of the litigation that was out there. And so measured by those top 10 settlements, we had the most success by the plaintiffs' bar and government enforcement litigators than we had ever seen before. So certainly if success begets copycats, what does this mean for employers in 2022? Well, I think you're going to see a lot of plaintiffs' lawyers, government enforcement litigators taking heed of those numbers and bringing similar cases and prosecuting similar theories in the hopes of pulling down similar recoveries. And so if you peel the onion skin back and look at the actual areas, those 5 particular areas, and the top 10 settlements in each area, what you see is that in 2 areas, wage and hour and ERISA, those top 10 settlements more than doubled as compared to the year before. Then when it comes to settlements for statutory claims, there was a 10-fold increase. Conversely, in the employment discrimination area and government enforcement litigation, those claims, when measured by those top 10 settlements, were slightly down. So certainly a gung-ho environment for the plaintiffs' bar, certainly in the wage and hour, ERISA, and statutory workplace class action areas heading into 2022. So if you look behind the numbers, I think my personal opinion, having defended companies throughout the United States, distilling these trends and reading all the settlements and all the decisions, is the #1 threat for employers in this day and age is basically how they pay workers. And that generates the most cases, and certainly in 2021, the settlements were double the year before. This chart shows settlements going back for the last 7 years, and basically what you see is about $500 million per year on average, $537.43 million to be exact, where employers have been paying out in these top 10 settlements in the wage and hour area. Cumulatively, over the last 7 years, it tops $3.25 billion. So clearly, this is an area where corporate compliance is important. This is an area where the plaintiff's bar is looking on a constant basis. And if an employer is going to spend $1 on risk management on the theory that corporate compliance dollars are well spent and certainly better than $1 spent on defending litigation, my advice is this is the area where that dollar ought to be spent, and where corporate compliance efforts have the greatest potential for a payoff in terms of these numbers. If we look at statutory class action claims, you see they went from about $250 million to $1.67 billion over the last year. This is where we had the most growth in any particular area, and this is where we're seeing what I call a migration of very skilled plaintiffs' class action lawyers into this area, where the legal talent is indicative of very aggressive, expert lawyers who know how to litigate these cases. One area contributing these numbers were sex abuse lawsuits brought against hospitals, universities that spiked settlements, for instance, against University of Southern California for $852 million, against Columbia University for $71 million. Another area is workplace privacy. One of the leading settlements of the year was $50 million against McDonald's for violation of a Biometric Information Protection Act in Illinois. One of the areas of concern for employers ought to be other states passing similar laws that would create additional causes of action. And in 2022, these workplace privacy cases now will be emboldened in New York, Maryland, and Kentucky, where those Biometric Information Protection Acts have been passed based on the model that started in Illinois that have generated huge amounts of settlements. So I think in 2022, employers can expect to see more creative lawyering by the plaintiffs' bar for these sorts of claims to be litigated and brought, because this has grabbed the attention both of plaintiffs' bar and of litigants in terms of the money that was made in this particular area over the past year. Not so much on the government enforcement side. As you see in this chart, is kind of a up and down line. A lot depends on the state of the White House. Is it red? Is it blue? And who is in charge? And I think that, as Paige had related, administrations don't turn on a dime, and it takes a while for their policy makers and their enforcement folks to get ensconced in positions of power in and have an opportunity to influence what is going on. And so at least at the Department of Labor and the EEOC, settlements were down this year. I expect those to go up in 2022 just because now the Biden administration has more of a grip and more of a control over those agencies, and certainly the leadership of those agencies are more aligned with the pro-worker, pro-union viewpoints of the Biden administration, and inevitably I think you're going to see more aggressive cases, more pushes for litigation, which inevitably will result in settlements. The second trend, and I think a very important one that employers should be mindful of, is what I call class certification trends. Why is this important? Well, class certification trends are about a calculus called class action conversion, and that is the plaintiff's lawyers' filing of their lawsuits, seeking, garnering, securing certification, and then using the leverage created by that fact to settle their lawsuits. And conversion rates and success factors are all about tracking how successful the plaintiff's bar and what sort of financial risks that employers face in these sorts of cases. In terms of what I do, one way to look at class certification is in this context. It's the absolute holy grail. It is the most important decision to be made in one of these cases, and it has implications that ripple through the case that impact the plaintiff side and the defense side. And once a case is certified, it invests the plaintiff's attorney with significant leverage. It hoists costs and risk upon an employer, and more often than not, certification can drive the settlement calculus and result in these large top 10 settlements that we were looking at. So every case is different, every judge is different, but the statistics that we generate by looking at all of these rulings are important and informative in determining the best way to craft litigation strategy and to map possible outcomes. So what we have done is tracked all of the decisions throughout the United States, put them in a database, and come up with statistics. And on this particular slide, we've highlighted the statistics from Fair Labor Standard Act cases, which are wage and hour cases, to give you somewhat of a state of the union insofar as these sorts of matters are concerned. So this is the #1 exposure, #1 type of lawsuit filing, and a key statistic that drives dynamics in this sort of litigation. And what we saw in the last 12 months was an 81% success rate for the plaintiffs in the initial certification phase of cases. So one way to look at that is to say basically 4 out of 5 cases brought and filed by the plaintiff's bar resulted in a conditionally certified case. So that's a pretty dramatic feature. Venue is important. It's going to be different in various areas of the country. A motion decided in North Dakota is going to be very different in terms of a motion decided in California. These are nationwide statistics in the book, and you can order the book for free at the end of the session today. There'll be a website that you can go to and pull down the ebook, and you'll see that the statistics are broken down by precedent and by state, and certainly those precedents are different and individual judges are different, and so all those factors are very highly determinative of outcomes. But one of the things we saw for the very first time in 2021, different than the previous 17 years, was the emergence of the Sixth Circuit. That's the Rust Belt Circuit, Ohio, Kentucky, Tennessee, and a higher number of wage and hour class and collective actions filed there and more decisions there than either the second, the Metro New York, or the 9th California region. The Sixth Circuit had more rulings and more positive rulings for plaintiffs than either the left or the right coast, which was different from previous years. So if you're a nationwide employer with operations throughout the United States, there's a high likelihood that you're going to get sued in either the 2nd, 9th, or 6th circuits based on these statistics, because the plaintiff's bar knows those are the particular areas where they have the greatest likelihood of success. Now, this chart also looks at decertification motions, and we'll get to that in a little bit, but basically a little bit of a jump ball. Employers were winning slightly more than half at 53%, and we'll show you a detailed chart on that. But now I wanted to switch to the comparison between wage and hour cases and employment discrimination and ERISA cases. In 2021, employment discrimination cases were certified at 72%. That happened to be the highest percentage since 2012. In 2011, a case called Walmart v. Dukes was decided by the U.S. Supreme Court, and most would agree that that particular decision made it more difficult, raised the bar for plaintiffs to certify employment discrimination cases. Well, fast forward basically 10 years, and during that decade, plaintiff's bar is nothing if not innovative, and they have begun to find ways to work around Walmart and to construct and configure their theories in a way to maximize the potential to certify their cases. And this year it came full circle, and they were 10% behind or 9% behind wage and hour cases. But again, a very, very dramatic statistic as compared to previous years, basically 7 out of 10 cases getting certified. In the ERISA area, those statistics were flat as compared to last year at 57%, But one way to view those statistics is that if you're an employer and you're sued in one of these workplace class actions, there's a 60% to 80% chance that based on the way the case is configured, based on the way the case is argued, and based on where the case is brought, there's a 60 to 80% chance that the case is going to be certified. So these are very telling statistics, very important for employers to be mindful of in this particular context. Now, I had said I wanted to break down some of the statistics for wage and hour cases since that was the #1 risk. Here's a 5-year running average, and you see for 2021, the average was 81%, much like 2019, and down 3% from 2020, but those were as high as they had ever been, and we're still at that 4 out of 5 in terms of decertification, where the judge allows the parties to take more evidence, probably a year to 18 months after a initial certification ruling. Employers were winning those cases a little more than half of the time. So there's a significant cost. There's litigation fatigue. There's money spent on moving the case down the track. And then it becomes a bit of a jump ball when you get there. So these statistics underscore why we have so much wage and hour litigation being brought against corporate America, because the plaintiff's bar knows that this is the particular area where that conversion rate from filing to certification to settlement stands the greatest chance of success for their particular size. The third trend to pivot off what Paige was talking about would be government, administrative, and enforcement trends. And this is an area where it's not called a class action under the case law, but it looks like a class action, and the risk presented by these sorts of cases is very much like a class action. And as Paige had mentioned, we're almost complete in terms of the new agency personnel being in place and certainly aligned with the pro-worker, pro-labor policies of the Biden administration. And slowly but surely, what we're seeing is pro-employer regulations being dialed back, more enforcement actions being brought, and those enforcement actions pushing the legal envelope, bigger cases, more systemic cases that involve more financial exposure. And so I think in 2022, based on what we have seen, if you're an employer, you can expect more aggressive investigations by the Department of Labor, the EEOC, the NLRB, the OFCCP. Certainly the EEOC is talking about bringing more lawsuits. And I think that the lawsuits that are brought tend to be what are called systemic cases, where policies are attacked that implicate numerous employees or groups of employees or hundreds, if not thousands of employees. So in my 4 years of practicing law, I think that this, to me, tends to be the most challenging area for employers. And why do I say that? Well, one of the dynamics is, unlike private plaintiffs' lawyers that have an economic model and economic incentives to litigate cases in a certain way, that sort of economic rationale doesn't really apply to government enforcement lawsuits, where injunctive relief, principal, deterrent effects are all very important to those governmental litigators, because unlike a private plaintiff's lawyer that's putting a third of that class action settlement in his or her wallet, that's not going on with the government enforcement litigator. And so to me, handling one of those cases is more like kind of grabbing a tiger by the tail and trying to hold on for dear life. The positions litigated by the government enforcement litigators tend to be much more aggressive and extreme, and the ability to settle the case typically is constrained and more difficult than when dealing with private plaintiffs' lawyers. So I think in 2022, employers should be mindful that this particular area of workplace regulation and enforcement is more likely than not to ramp up and be more difficult than it was in 2021. The next area that I think was a significant trend is what I had referred to earlier called the COVID overhang. In my way of thinking, COVID impacted everything that had to do with the law. Courthouses certainly were not shut down. Over the last 12 months, I tried 2 cases inside courtrooms wearing a mask. And so the business of federal courts and state courts kept going, much of it on Zoom, but there were more class certification decisions issued in 2021 than there had ever been before. So the dispatch of judicial business went on despite the continuing impact and the ups and downs of what COVID-19 meant. So it impacted litigation generally, but certainly in particular impacted workplace class actions. It also spawned a lot of additional theories and a lot of additional class actions. I defended a couple of college tuition reimbursement cases, and virtually every college and university throughout the United States that had to take measures with respect to the pandemic ended up getting sued over tuition issues. There were consumer fraud cases brought against a myriad of companies with respect to issues with products, processes, anything that had to do with safety, health, COVID-19. There were workplace safety investigations and lawsuits brought. There were lawsuits brought by states, municipalities, unions, private employers, against private employers with respect to their treatment or rules or regulations involving bringing people back to work or working during the pandemic. And then there were challenges to executive orders or new laws issued at the local, state, federal level with respect to regulations involving COVID. And so one of the ways in which we measured that was to look at the success rate for rulings in this particular area. And not unlike single plaintiff litigation, certainly in the class action context, sometimes plaintiffs move for a preliminary injunction on the theory their case is so strong and a judge needs to act and enter an order to correct the issue that they move for a preliminary injunction. And we probably saw more preliminary injunctions in class action litigation than ever before. And basically, these were brought against 2 types of defendants. One was against government officials, either mayors, governors, and in many instances, the President of the United States or head of agencies that had passed regulations or enforced laws with respect to COVID in the workplace. By and large, courts were siding with the government. It was close, but 41 to 59%. But this was an area of great flux and change, very difficult legal terrain, where you would see rulings and then government officials then amending laws and putting into place revised laws based on these rulings. So to have the scorecard and keep up with it was a full-time job and very difficult. We started out with a 1-page spreadsheet and ended the year with a spreadsheet of over 1,000 pages just based on COVID laws, regulations, and rulings in this particular area. So a true patchwork quilt of laws and regulations that employers would have to comply with. There were also many challenges brought against private employers, and typically they would be brought by employees, sometimes applicants, often by unions, saying that the policies and procedures adopted by the employers somehow violated a contract, violated a federal or state law, violated a constitution in terms of what it required workers to do in coming back to the workplace. And by and large, what we were seeing there is judges were backing up employers, and more often than not, employers were winning those. My personal prediction would be, knock on wood, hopefully the pandemic continues to subside and we won't have another generation of new bugs that are visiting our locale, states, and workplaces. And as we go through 2022, more people will be returning to the workplace. But I think what you're going to see then in terms of this COVID overhang is not only the work off of these particular actions, but new types of risks. And I think those 5 areas would be a reasonable accommodation of infected workers, challenges to vaccine mandates that private employers would put in place, liability in the workplace for transmission of the virus, wage and hour claims for remote work to the extent that people have a hybrid working relationship, and then breach of privacy for monitoring workers, especially remote workers. So I think those risks are here to stay, and I think the COVID overhang will be here for another year or two in terms of workplace class action litigation. The final area is arbitration and its impact. And by my way of thinking, this is the #1 defense and the most successful defense that employers are able to mount in terms of an ultimate defense device to keep out of workplace class action litigation. Depending on what sort of survey you look at, most people think that about 60 to 70% of private employers have adopted some sort of ADR programs, but there were over 100 rulings where judges gave a red light to the plaintiff's bar in a class action, gave a green light to employers to get out of the court system and to enforce their arbitration agreements, whereby a worker who brought a class action could only litigate their claim in a confidential arbitration on an individual basis. As Paige alluded to up on Capitol Hill, there are bills to overturn parts of EPIC system involving claims for sex harassment or other areas. There are attacks on the entire ruling to abrogate it. And so I think that employers would be well served to keep track of this particular area to see what is going to eventuate here in trying to control their litigation risk through use of arbitration agreements. So what do all of these developments in this tour of the workplace world mean for employers into the coming year? Well, I think the first principle that needs to be recognized is success begets copycats. And these large-scale settlements involving millions, if not billions of dollars, generate a lot of social media publicity. Employees read those things, and they visit lawyers and talk about bringing class actions where they think something might have happened to them. And so I definitely believe in 2022 there are going to be more class actions filed than there were in the previous year. And certainly the lifting of the pandemic will contribute to the volume of those particular cases. I think the second takeaway is the way in which employers pay and compensate employees remains what I call the key inflection point for workplace class actions. Wage and hour cases will continue to be the #1 risk, the #1 filing, and an area where the plaintiff's bar tends to make the most money and continues to track those statistics that we saw throughout 2021. With the Biden administration's focus on workplace issues and its championing pro-labor policies, I think inevitably there's going to be more government enforcement litigation than the year before. And I think it will increase in volume and intensity in terms of the push the envelope type nature of it and the amounts of employees at issue. And this is an area where any employer under the scrutiny of the government, as I had said before, a tiger by the tail, a very difficult area. I think there are many COVID class action claims in the federal and state court systems. Those will work out, and as workforces begin to return to work or have hybrid arrangements where they're part remote and part in the workplace, you're going to see variations on those class action claims being brought. And then I think the final area is arbitration. The defense remains viable. By June of 2022, the U.S. Supreme Court will be passing on a case from California called Viking River Cruise. And there is the potential that it will close the one existing loophole that exists for employers in California for arbitration defenses. It's known as PAGA claims, private attorney general claims that are brought based on the public policy of the state of California, which thus far the California Supreme Court have said are outside the purview of the Federal Arbitration Act and may not be compelled to arbitration. If the Supreme Court should say that intellectually there's no difference between its decision in Epic Systems in 2018 and the application of the FAA to PAGA actions, it will be a very interesting political dynamic and query whether or not that will fuel efforts at the federal level to overturn the Epic Systems decision or the Supreme Court's views as to the bar created by arbitration defenses, and query if the Supreme Court should not overturn and greenlight PAGA claims, whether or not other states besides California will begin to expand legislation to allow workers and their advocates to bring those sorts of claims in the future. So I expect that decision by June, and it'll be a very important bellwether decision in terms of probably these public policy notions underlying arbitration. So what can employers do? We'll end on that. By my way of thinking, solid HR fundamentals have never been more important than before. The simple blocking and tackling of being a good employer with sound and HR policies, procedures, the way in which they're implemented, having what I call early warning systems, grievance policies, HR hotlines, ethics lines. None of these class actions should come as a surprise. More often than not, these early warning systems can allow an employer to detect a problem, to investigate it, resolve it, and try to avoid the heartache of one of these claims becoming a class action brought against the employer. Remember also that a claim might seem small when it's brought, but it has the potential to expand. Basically, we see that with EEOC charges that might involve one worker, or a Department of Labor complaint involving one worker, and then that federal agency begins to dig in, investigate, expand, and claim that the investigation at hand involves multiple workers, hundreds of workers, thousands of workers, and turns into a pseudo class action. The plaintiff's bar tends to do the same thing. And remember that kind of workplace ideology of, is arbitration good? Is arbitration bad? Is that consistent with my company culture? The statistics don't lie, and they show that the best way in which employers have been winning these cases, avoiding the expense and heartache of defending them, and not having to pay these large settlements, is through good arbitration programs that involve class action waivers. So that's an awful lot and a big tour of the world in terms of what occurred in 2021. And like Paige, look forward to answering any questions either at the end of our session today in the few remaining minutes we have, or online for any questions that came in. But thank you so much for the privilege and honor of being with you today and talking about these issues.
Terrific. So thank you both for your wonderful comments. Really appreciate that. And I want to thank our audience members who have been engaged this entire time and asking questions during the presentation. We obviously can't address all the inquiries and comments, but I thought I might ask a couple questions that did come into us. So the first question I wanted to direct to Paige. I think a lot of our listeners and viewers were very interested in the impact of COVID-19 on labor and employment issues. So we have Aaron from Dallas who's asking about your coverage of the impact of COVID-19 And what was the most unexpected area or areas of change to you? Can you talk about some stories or topics that you're seeing that you haven't seen in previous years or pre-pandemic?
Certainly, and thank you so much for the question. That's a great one. We sort of joked on our team that as soon as the pandemic hit, everyone sort of became a labor and employment reporter because it really just it the pandemic hit every corner of the universe, obviously, but I mean, especially the workplace. Like that was just it so keenly changed and so quickly changed so many, day-to-day things that we'd sort of taken for granted, if you will. In terms of stories that I wrote that were really interesting or kind of surprising to me, one story that I wrote, and I don't think I ever heard of this actually happening after the fact, although I kind of heard anecdotes of like similar situations. But one story we wrote that dug into this idea of like employers asking whether they could segregate employees based on vaccination status. So, have your vaccinated employees on one floor and your unvaccinated employees on another floor. And again, that's just kind of a situation or circumstance that never would have occurred to me if not during a pandemic. I mean, that just wouldn't necessarily happen. But in terms of things to sort of watch in this area, I mean, I think that you know, as employers and employees catch up to this, lawmakers are always a little bit behind, frankly. So I think that we'll continue to sort of see the fallout, as Jerry said, the kind of overhang of COVID-19 on Capitol Hill. And, down the line, I think that we'll sort of still be grappling with these larger issues around equity, for example, issues around worker displacement and from the workforce, issues around, um, just longer term issues, if you will. So I think lawmakers are grappling with those questions, and we are too. Thank you.
Excellent. We have time for at least one more question. So Jerry, one came in here about recent shifts in the labor force and how they may impact key areas like class actions. And if you can go further on that topic, do you think that we're going to be seeing more of the same in policies put forth by federal labor agencies? And do you expect trends identified in government enforcement to continue to favor a pro-labor movement, or will it be tempered as the U.S. stabilizes and things become more or less, sort of a return to normal?
Well, my personal prognostication, having lived through this before with other administrations, is I think that measured is a term that it's kind of like beauty is in the eye of the beholder. And it might be measured insofar as Democratic-controlled agencies are concerned, and it might not be so measured compared to the way a business views it. But I definitely believe that unlike the prior Republican administration, you're going to see more cases. They're going to be targeted against industry leaders or cases involving large groups of employees, tend to be very messy, very complex, very expensive, and that the agencies will be very, very aggressive, and that the number one issue for them is enforcement of the public policy behind the laws that they are entrusted to enforce. And so I think that it will be a bit of a new day and age. It will be more difficult for employers, and maybe viewing the risks through the old lens, maybe during the prior administration, it's not so bad, we can deal with it. I think it's going to be a whole new calculus of risk over the next 12 months.
Great insights. Well, thank you to Jerry and to Paige, and Paige, especially to you for being our special guest today. We really appreciate your insights and your participation. So on behalf of our participants, thank you so very much. Congratulations to you, Jerry, on another successful report, and hope we see you all soon on another Seyfarth webinar.
Thank you.